Hello, YouTube. I'm Vince White. I am an employment attorney. Yes! I don't know. I don't know. I make a lot of videos today. Trying to keep it fresh or something. I'm an employment attorney. On this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user, that could be a full name, so we're just going to call her Angelina. YouTube user Angelina, who has great sunglasses and great shades. Very big fan of the mirrored aviators. Very baller move, Angelina. Okay, we'll read the question in the record. I have a pending case already filed in federal court against my employer. I just filed another EEOC case for retaliation against my employer. They have failed to provide correct information for the first case and have now refused to mediate for the second case. My question is, would both of these cases be combined into one case in the court system, in the federal court system specifically, I think? Or will I have to file another case against them if and when I receive the letter of right to sue? Angelina, what I would recommend is, one, it sounds like you're not represented. Gotta say it. Recommend counsel. That'd be a great idea. But assuming you don't have counsel, or for whatever reason your counsel doesn't know this, which should concern you if you have counsel and they don't know this, or it should also concern you if you have counsel and you don't feel comfortable having this conversation with them. That would be concerning to me. But if you contact the EEOC right now and you have that open retaliation case and you tell them, hey, I have a federal case and I want to combine everything in one action, it would be more convenient for the court and everyone involved if I was able to get my right to sue letter for this retaliation case right away so I could get this amended into my federal court proceeding. Then there's a really good chance the EEOC will issue that right to sue letter, both because they don't like to work, and that means they don't have to work if they just give you the right to sue letter, and also because they do kind of like the federal court system. Like, the EEOC exists in part to keep the federal court system from getting overwhelmed with these cases. And so they might think the least they could do is try to make things slightly more convenient for a federal judge, right? Now, in terms of amending the retaliation claim into your federal litigation, first and foremost, let's already say wherever you are, you may have state law claims that you could also add into your federal proceeding. Those could be whatever underlying protected class, discrimination, sexual harassment that you're dealing with, which is, I assume, what you're suing for here, but also for the retaliation. And those state law claims, you would generally not need a right to sue letter to bring those in federal court. You do need the right to sue letter to bring your federal retaliation or workplace discrimination or sexual harassment claims in federal court. So check the federal court's rules and see how long you have to amend as of right. Right? If you have 120 days to amend your case as of right, then if you can get that right to sue letter in the first 120 days after your case was filed, or whatever the rules locally say, then you can add that in. You can amend to add that retaliation claim under the federal law in, and also you can amend in any of the state or local law claims that you may not have already added, right? I don't know that you did or didn't. I'm just throwing it out there. Is that something you may want to look at that could add value and reduce risk to your case, especially if you're representing yourself, right? So that's the first thing. Now, if you're already beyond 120 days or whatever the local amend as of right period of time is where you are in your federal court system, that's fine. You can seek leave to amend, and in that leave to amend, in that request, in that motion you're making to the court, you say, listen, this is going to be better for everybody if you let me amend this in, because it's going to preclude there being a second action. We can litigate all of this in one place. It's better for the court. It's better for the defendant. It's better for me. Everybody wins if we can have this one overarching action to dispose of all of the horrible things that were done to me in this workplace. Very logical. I can't imagine, there's too many judges who would say, no, I hate efficiency. Will there be some judges? There's always one. There's always somebody. Listen, judges are human beings. And so, sometimes they're going to make decisions that are going to make you say, like, really? Really? I had a professor in law school who, if she didn't like your answer to a question, be like, really? And, like, being a law student, sometimes you'd be like, yeah, really? She'd be like, really? Which is just another way of saying, Stop being stupid, stupid. But we never did. We never did stop being stupid. And here we are today. Anyways, Angelina, great shades. I hope this helps you. Good luck to you. I hope you get everything amended and into one action because that would be better for everyone. Be smart out there. I hope you win. Remember, not everybody works. Everybody works. Not everybody wins. So I hope you win. If this was helpful, like, subscribe, comment down below. It helps me to help more people just like you. Take care.